Hi, Dr. Marlene Mireles, physical therapist here with the Pediatric Telehealth Coffee Hour. I'm here with Texas attorney Samuel Morales, and I'm meeting with him today, and he agreed to this interview to share with us information on what we should have in our contracts. So by the end of this presentation, you should have a better understanding of what you need to have in your contracts to protect you. So thank you, Sammy, for coming on this show today. I'll go ahead and let you take it from here.
Hi, I'm Samuel Morales. I'm a Texas attorney, and thanks for having me. So today I'm going to talk about what makes an enforceable contract and various provisions that you might want to have in your contract. So contract law is it can vary a little bit from jurisdiction to jurisdiction, from state to state. Even within a state, let's say, for example, you have a certain statute, case law actually interprets how that statute is interpreted, and sometimes jurisdictions interpret these statutes differently. In this situation for physical therapy, you're actually using common law contract law versus UCC, which would involve the sale of goods. This is a service that you are providing, so in terms of the law, it's common law that dictates your contract and how it's enforced. In reference to a contract, it's very important that there are several elements that have to be fulfilled in your contract to make sure it's actually enforceable. If any of these elements are missing, then your contract may not be enforceable. For example, mental capacity, okay, is an issue that may come into play in your line of work if you're dealing with the elderly. A patient needs to have the mental capacity to actually even enter into a contract. So if it's a minor or an elderly person, this comes into play. As far as the elemental aspects of it, so you have what's called the offer, acceptance, consideration. Okay, the offer is the offer that you're making. You're offering to provide your services in a certain way at a certain price. You want to structure your contract so that when you make your offer, all the client has to do is say yes or sign on the dotted line, for example. That serves as the acceptance. Now, your contract, in order to be a valid contract, also has to mention what we call legally consideration. What consideration is, that is what you are getting for the contract. How are you being paid? How are you being compensated? You need to have offer, acceptance, and consideration in your contract. Otherwise, your contract may not be upheld in court. Okay. In reference to acceptance and the offer, one of the things we look at is what's called a mutual agreement or a meeting of the minds. Your contract should show that you have a meeting of the minds, meaning you're articulating the proper expectation about your services in your contract. Your client, having that proper expectation, is willing to accept it. If you all have different ideas of what the contract means, it means that that contract may get thrown out in court. All right, so it's very important. Again, just to reiterate, mental capacity is going to be an issue for you because you may be dealing with therapy for elderly or even minors. One thing that's very important also is keep in mind you may want to, for the elderly, whoever has, let's say, the power of attorney or potential guardianship for an elderly person if they're mentally incapacitated, that will work. They can sign, for example, as an attorney in fact. Somebody with that power of attorney, that we can make sure your contract is actually enforceable. All right. Those are the core elements of a contract that you're going to want to ponder and think about when you're having your contract drafted. Obviously, it's always best to use an attorney, such as myself. I do practice in Texas. Now, outside of the elemental aspect of a contract, there are certain provisions that you're going to want to have in your contract.
Can I ask a question, Sammy?
Yeah, ask away, please.
I figured I'd ask now while we're talking about
Go for it.
The offer. So I know when we've talked on the phone prior to our Zoom meeting, another thing that, because Sam went over my contract, and so I got to see what I was missing. And one thing that I wasn't doing, which I can see now how it would be a good idea, is in the offer to include, because I have a cash-based practice. Mm-hmm. So I think from after talking to Sammy, it is important to have your rate and what they're paying in the offer to prevent confusion. Because on a couple occasions, I've had a patient come back and say, well, I thought it was this amount. And then I ended up giving them a lesser rate, especially when they're buying packages. and they're
Mhm.
getting discount combined packages. So I just wanted to add that in there so I don't forget.
Okay, did you have a question?
No, it was more just about, there was a question that I had
Okay.
asked you previously and you answered for me. So that was
Okay,
the answer to your question and I just
gotcha.
said it. Okay.
Perfect. Okay, so moving forward to clauses or provisions that you might want to have in your contract. You're going to want to have some type of a limitation of liability provision, something that's going to limit your liability. I mean, you're dealing with with people's medical needs. Somebody could get hurt by accident. You want to make sure that if you do get hurt by accident, you're not going to lose everything you own. Okay. Um, Many people may have the inclination to practice as a sole proprietorship, and this is kind of outside of contract law, but you want to make sure you're going to have your LLC or business association set up to limit your liability also. And that's going to be another layer that's on top of or in addition to your contract itself. Your limitation of liability, for example, could be limited to, let's say, medical expenses if they're injured, as opposed to, maybe it can have an exclusion of pain and suffering, for example, or limited to a certain dollar figure. Sometimes a limitation of liability clause, if it's not drafted properly, it can be thrown out, and it's like pointless to even have it. You can't just, for example, limit all your liability and say, I have no liability if I do something fraudulent or commit negligence. That obviously is not going to fly in court. So you need to be very specific and tailor your limitation of liability clause to make sure it's actually going to be upheld in a court of law. All right. Other things you're going to want to think about. Right now, especially with the pandemic going on, you probably have a lot of telehealth going on. So you may or may not be dealing with people that reside in your jurisdiction. All right. For example, I'm in Texas. Some people may be close to the border. They may be dealing with somebody in Virginia or Florida because of telehealth reasons, and maybe they're licensed in other places. You do not want somebody to sue you to be able to drag you to some far off jurisdiction. If you're practicing in Texas, what happens if you get sued in Florida? Well, if you took a client in Florida and they live there and you availed yourself to Florida, they can sue you, and you're going to have to fly out to Florida, hire a Florida attorney, and the cost of litigation when you have to for an out of way place greatly increases. So what you're going to want to do is you're going to want to have what's called a choice of law provision or a choice of form or venue provision or clause. Okay. So what you're going to do is you're going to say, by signing this contract, for example, you agree to Texas law, and you have to be, if you're going to take me to court, it has to be in Bexar County. These are things that people agree to do in contracts, and it can protect you from being dragged out to a foreign jurisdiction. All right. So the choice of law, choice of form or venue provisions are very important to have in a contract. The next thing you're going to want to do to limit the probability you're going to end up in court in a hearing or a trial is to add an arbitration clause or a mediation clause. What that says, it essentially means that all parties agree to use a third-party mediator or arbitrator to resolve any legal disputes. What that does, obviously, it means that if you get sued, you're not going to end up in court in a costly trial, so it can save you money. All right. Marlene, did you have any questions for me about any of these provisions I'm mentioning so far?
I do. So for the limitation of liability clause, you said you don't have to put an amount. You can just specify the type, but is it better to put an amount to be?
Well, this is where it really makes sense to have an attorney, right? Draft these provisions for you. And the reason being is that based upon your choice of venue, you may draft the provision differently because different jurisdictions may have different interpretations of common law.
Okay. So like
So if you're in Bexar County, for example, where I'm at, I would look at the case law for my area to see how courts have decided certain issues, and I would draft my provision accordingly.
okay. So just because, as a therapist, we have professional insurance, we wouldn't necessarily put the max amount that they could use.
No, exactly. Now, after talking with you, just on the insurance side of it, I do not know if this exists, but it would be rational for it to exist. Um, it would make sense for an insurance company to want people like you to use attorneys to draft their contracts, because that's also limiting the insurance company's liability. Does that make sense?
Yeah.
Because if somebody sues you, who's going to pay? Is it going to come out of your pocket, or is it going to come out of the insurance provider's pocket?
Right.
So that may be something you might want to consider speaking to an insurance company about, to see if you can get a lower rate for your insurance, because there is a direct correlation between your contract and your liability and your insurance provider's liability.
Okay. Makes sense.
Yeah. Okay, so moving forward, another important provision is what's called an integration or merger clause. All right. When you're talking to your clients and you are forming a relationship, people always want to they have this natural inclination to make promises or to say what's right for the moment, right? And essentially what you're doing is you're running that agreement may be outside your contract. What a merger clause says is this: it says that no prior promises are in effect. Everything about our contract, the scope of what I'm doing, is in the four corners of this document. If it is not in writing and not in this document, it is not part of our agreement. If there are any changes to the agreement, they have to be done in writing. Okay. Now, this kind of seems like a pain in the butt, to be honest, right? Excuse my language. But it protects you. Many times when you have a breach of contract claim, it's because somebody said, oh, little Johnny told me he was going to do this to my carport after the fact, but I know it's not in writing. Well, if you don't have an integration clause or merger clause, it leaves you open for litigation. The merger clause is the client agreeing and they're saying, look, unless it's on these pages, it's not part of the contract. Okay, I'll initial next to it, and it covers you. All right. So the integration or merger clause is very important. It limits the scope of your transaction to what is on paper in your contract. Understood? Did you get that, Marlene?
Yes, I'm muting myself, so if
I
my
got that.
in
Not
the
a problem.
background,
Okay. Now, the next provision I'm going to talk about is what's called a savings clause. All right. A savings clause is very important. It's usually a small provision in pretty much every contract. It says that if any provision or any part of your contract that you have with your client is deemed inadmissible or not applicable or cannot be enforced, it says that every other provision other than that one is still active and in effect. So essentially, if you have one issue with your contract, it makes it so that the entire contract is not voided as a result of that one issue. So when you're in court and you're being sued for breach of contract or whatever it may be, that other party can't say, look, this contract is faulty, it's not valid because of element A. Well, you know what? Element B, C, D, and E are still going to be active at that point because you have a savings clause which saves the rest of your contract, and only that one provision that is invalid will be excluded at that point in time. And those are the basic clauses that you're going to want in pretty much every contract. There are other ones, and it may vary from jurisdiction to jurisdiction, but those are the basic ones that every contract should have. Any questions for me, Marlene?
No, I don't have any questions. I just wanted to mention that based on our conversations, I made an infograph so that way when people watch the video, they can follow along. And I did include some other forms to make sure that you have like the financial responsibility form, and some of it maybe also be covered in like the offer, but also letting them know if they need to file claims to seek potential out-of-network reimbursement if you're cash-based, or if you will or will not be providing them a super bill, and your cancellation policy. So I know some of that may be repetitive.
Okay, so that reminds me, actually. So you had mentioned before a contract. Okay, I'm kind of jumping around here, sorry.
Okay.
A contract is very important because when you have any type of business transaction, right? 90% 90% of all conflict can be eliminated because if you set the proper expectation.
Right.
Well, your contract is your tool to set that proper expectation.
Mm-hmm.
By having a thorough, not just thorough, but a contract that's easy to understand, your clients are going to be happy and they're going to have a proper expectation of your business transaction,
Right.
which greatly decreases your chance of ending up in litigation.
Right.
Your ability to communicate, not just orally and in person, but when you're going, I recommend whenever you sign a new client, don't just hand them the contract and say, sign here.
Right.
You need to read your contract, you need to understand it, and you should be going over your contract with your clients. And it's a pain in the ass, but it can be done, excuse my language, sorry. It's a pain, it can be done easily. It'll take you 5-10 minutes probably, and it can potentially save you thousands of dollars because you're setting proper expectation.
Makes sense.
So that's very important. You also have a financial responsibility disclaimer in your contract. Did you want to talk about that?
No, you can talk about it.
Okay. Your financial responsibility is just, you're essentially, again, setting the proper expectation for your client in reference to who has financial responsibility, what are the costs associated with it, is it in network, out of network, what can be submitted to insurance, right? You had also talked about a release form.
Right. And
go ahead.
I know when we talked before, and you had mentioned that if your contract does end up being like too wordy and not simple and like all those fine print where you can't really read, that sometimes that.
Correct. There are certain things that that can make a contract hard to enforce. Everybody's gone to a bank or to some business issue where you have this contract and the contract is huge, the print is tiny, and no one's ever going to read it, right? Those contracts many times are hard to enforce. They're hard to enforce because sometimes it's on a take it or leave it basis, which is one of the things the court looks at. The more simple you have your contract, the easier it is to understand, the better. Sometimes though, in a complicated business transaction, that's not feasible, but in your situation for physical therapy, it may be. And I think that's all on that topic. Any other questions?
No, not on that topic.
Okay. You had also talked a little bit, what was it here? You had a release form I think you wanted to go over.
Right. Just a release form for, when you have your own business, how you want to use testimonials, photo, video.
Okay. That makes sense. So on that note, if I recall, from yours in particular, you had an option in your contract to, after the client's already agreed to it, that they can opt out after the fact, and then you would stop using their material. Now, you need to be really careful with that, okay? I recommend only doing the opt-out at the very beginning. They can agree to it. If at some point in time in the future they decide they don't want their likeness on your material for some reason, then what you would do is on your next print around, when you print your new documents, you would just have it changed. But what happens is when you go into court on such a matter and they've already opted in, right? Maybe you're doing a free eval, and that's part of the release form of the consent to use their likeness for doing the free eval, right? So there's an exchange. That's what's called consideration. So that makes the contract enforceable. If you've already taken money after they've already given their consent, and you've taken money and you've used it to create marketing materials, no court's going to hold that against you because you relied upon their word before you had an outlay of expense. They opted in. Now, if at some point in the future they come back and say, "Oh, we don't want you to do that anymore," you're covered legally. You can still use it. Now, out of respect, to save a relationship or to prevent having to defend a suit, you can say, "Look, I completely understand. I already have this outlay from marketing material that I've already spent because you gave me your consent. My next go around, I'll change it up to make sure your likeness is taken out." So I wouldn't even mention in your contract the option to opt out later. Have them opt in your initial contract. Then if there's an issue later on, let them contact you.
And I don't know if you noticed, Sam, I sent you a photo release form video that you signed, and I took that part out. So you're in. This
I
is
know, I know. I read it. I thought twice about it too, man. See,
you opted in.
it's a negotiation agreement right there. We
Yeah,
negotiated something.
yeah. No take backs.
There you go.
I'm just kidding.
Okay, was there anything else here? Informed consent. Okay, so informed consent. Obviously, you're going to want, that's part of setting proper expectation, informed consent, right? So it's not necessarily it is a contract provision, but it's not like your typical clause, but you should have one in your industry. Informed consent needs to be in your contract. You need to point out the risks associated with your service. And that is actually a form of a limitation of liability clause, to be honest. It's informed consent. These clauses, these provisions are meant to limit your liability. So if there's any kind of danger, if there's a danger of being hurt, you need to make sure when you're going over your contract to go ahead and let your client know that, and they're agreeing to take the risk, essentially. So what that does, it means that outside of something that's negligent on your part, you're going to be covered.
Right.
Another thing you're going to want to include in your contract also is a provision that states that it is the client's responsibility to update you on new medical conditions.
Right.
What happens if something happens to your client and they have some type of injury, you were never made aware of it, and you're working on the client because you were not made aware of it? What, are they going to sue you if you hurt them? Well, it's not really your fault if they didn't tell you about their condition. So you want to address that in your contract as well. Be preemptive.
Right. And that's something that I didn't have in my contract before, but now I will be adding that because I can definitely see how important that is.
Correct. Yeah. Any other questions for me?
Nope. The last part that I had added in here was you want to make sure you have your notice of privacy practices, and that's required by the HIPAA privacy rule for covered healthcare providers. So like my business is cash-based, so I don't accept insurance, but I still have a notice of privacy practices.
And that's very important. When I'm speaking to, or when I have been speaking today, I wasn't speaking with HIPAA in mind. I'm just talking general legal principles. So any type of federal statute that applies to your business, educate yourself on it. Take the time to read that material, because it will potentially save your business and save you a lot of heartache and money.
Mm-hmm. And so this interview today, so Sam went over, in general, what you need to have in a contract to make it valid. And then we added the financial responsibility release form, informed consent, and notice of privacy practices. So that way it makes it more usable also we need to know about contracts and for our healthcare practice, like what else we should include in it. So I feel like everything went really well, and I have a better understanding, and I hope that you all have a better understanding also. And Sam, was there anything extra that you wanted to add? Definitely how to contact you.
Not at all. Yeah, well, yeah, I am licensed to practice law in Texas. If you need to reach me, by all means, please give me a call. My telephone number, my business line, is area code 210-394-1830. That's 210-394-1830. And I am Samuel Morales, and I hope to hear from somebody.
Good. And I also added Sam to the group, so that way he can see any comments and answer any additional questions, or you could message him privately, so that way it's easy to contact him. And I know that there are a lot of therapists that live in Texas that are in the group. And I think this was a great interview. And I do have one last question for you, Sam.
Ask away.
How do you drink your coffee? Because this is the pediatric telehealth coffee.
Is that what it is, huh? Oh, black with sugar, of course.
Okay, great. I love that. All right, well, y'all have a great day, and thank you again, Sam, for joining us today.
Hey, thanks for having me.
Bye.
Bye.
Oops.
Are we off?
Nope, not yet. Okay.